Chair. I'm going to concentrate on those new amendments to the bill that's coming for us that relate to the tenancy protections. And I hope to ask a series of questions that I might expand on then with answers. So just in regard to the dates that are selected, it talks about tenancies who are currently who at any stage between the 1st of August and the 12th of April were on PUP payments and so on. Why was the 1st of April applied as opposed to 1st of August rather than the 1st of April? For example, people could have been under a PUP payment between April and August and therefore have built up arrears, but they wouldn't now be covered by this bill. That's my first question. You've answered the question about both the landlord and the tenant being covered by the same penalty for false declarations. I then turn to the 5-day period in which the tenant needs to respond to the notice to quit. I feel that is far too short, and the idea that the tenant would have to make that within the 5 days, and that the RTB then would pass on that data to MABS, and I imagine there are GDPR issues there. And so I would query that. And secondly, has any consultation with MABS taken place as to the additional work which will be required? MABS is already a very oversubscribed service. I think there is an attempt here to balance landlord and tenants' rights, and I accept that if that was a bigger piece of work around tenancy's rights. But the genesis of this is about preventing people having to move around during restriction periods. Remember, I can't go and visit my mother in her home today. That's the environment that we're in. This is not an overall project about balancing landlords, tenants and rights. And so I think some of the requirements in it, we really haven't thought out the details on it. So, for example, on the enactment, on the expected enactment of the legislation on the 19th of December, the RTB then is going to write to all of the people who've been impacted to alert them that they must lodge an application with the RTB and then on to MABS. They must do that within 5 days. We're talking about between the 19th of December and Christmas Eve, the RTB sending out letters to tenants. I just think that's a bizarre timing for it to be done, if nothing else. I then move on that within 5 days of the commencement of the bill on the 16th of January, which would bring us to the 16th of, sorry, 11th of January, which would bring us to the 16th of January, with most places returning on the 2nd or 3rd. You have a very short period of time again for people who've previously applied for the exemption. They then get a letter before Christmas from the RTB saying that they must contact the RTB and apply to MABS, and that all has to be done by the 16th of January. I just think that timing hasn't been thought out at all. I then am very concerned with the answers you gave to Senator Cummins in regard to disapplying. So this is about giving tenants certainty that they don't have to move around during restricted periods of a pandemic. It would appear simply by making an application, that right is extinguished. That certainty is extinguished. So if a landlord suggests that this is his sole income and he makes that submission, the tenant is no longer given the certainty that we want this eviction ban to give. And I accept you say that other recourse is given under the normal notice period. But let's be clear, the main provision there is time. It's not in any way additional rights. I have no issue with balancing landlord and tenants' rights, but I think that is a bigger term project, and what we should be doing here is giving tenants certainty. The timelines of 5 days is too short. The timelines over Christmas, I believe, don't take account of the seasonality, and I certainly think some of the issues around the transparency of data, for example, that the tenant is in arrears, that a tenant who has failed to provide the RTB and MABS with the required information, right? The landlord, if he submits that that's the case, then the right disapplies. But how would the landlord know whether that happened or not? Again, I think we're attempting to do something here that's a bigger project, and I think amendments will have to be made at this point. I'm the third government Oireachtas member here who's expressed concern at this, and I imagine those other members of the committee are going to be louder on it, so I do have issues with it.
Thanks, Deputy McAuliffe. Mr. Ross.
Thank you, Chair. If I might come in on that one. I'll try and pick up everything, but please do come back if I haven't. First of all, on the 1st of August to the 12th of April, the previous RTVA looked back till I think the 30th of March, but the view is that that Act protected people who were in receipt of payments during that period of time. So if you were in receipt of payments between March and August and beyond right up until the 11th of January, you're covered by the RTVA Act. And you could still make a declaration today and right up until the 10th of January under that Act. But looking forward, we felt it was reasonable that, you know, that Act, the RTVA came in on the 1st of August. So that's the time that we're looking back to on this one, because the previous period was covered by the RTVA itself. That's the logic behind the timing. I'm trying to read my notes here. 5 days, sorry, there's one here I can't read, but I'll come back to it in a second. 5 days to respond. Look, I think the view here is that when you make a declaration, the document that will be sent out will include two things. The declaration to the RTB, but also a request to the RTB to put you in touch with MABS. So that'll happen immediately. The RTB get it, they'll put you in touch with MABS. Separately, the request is that you engage with the landlord for consulting regarding an arrangement within 5 days. It's to put an obligation on people to make that happen. It's not that the agreement has to happen within the 5 days, but you must engage. And part of the concern here, Deputy, is that with 348 declarations, we've only had recourse to 7 people going to MABS. So there's an uncertainty as to what others are doing. Have they reached agreement? Have they not agreed? We don't know. And maybe then, I think the GDPR issues will be addressed because you will volunteer you will make the request as the tenant yourself. And I think that addresses that. I will double check that, but I think that addresses that. Additional work for MABS. We think that in the context of the overall numbers presenting at the moment, this isn't an issue, and we consulted with the Department of Social Protection at the time of the original Act, so I don't think we feel that that's an issue. There's an important point here, though, that I would like to make. The genesis of this one is not public health. The genesis of this one is the economic fallout as a consequence of public health. And that's why the interests of the landlord have to be given the weighting that they are.
So can I ask a question? That's a very profound thing to say, Chair. Apologies. Is that the view of the department?
This is the first bill, the RTVA bill, was brought about, and I think you'll see in the recitals to it that it talks about the economic fallout as a result of COVID-19. And this is subsequently, it's about rent arrears, so this is an economic issue, it's not a public health issue, and there's an important distinction.
You realise we've just come out of level 5 2 weeks ago?
I do, but I also would point to you that the Act that we enacted back in August, which was called the Residential Act, Tenancy Act 2020, which we enacted in August, provides separate protections. Anyone in a situation where their movement is restricted by 5 kilometres cannot be evicted from their tenancy. That applies any time that restriction is in place. If that restriction were brought back in tomorrow, there would be a moratorium on evictions for everyone for that period of time. So the two provisions exist in parallel with each other, but this is purely an economic fallout as distinct from that which is the public health one. Now, if I may come on to some of the other ones. Okay, on the 19th of December, because we know there are 348, on the 19th of December, the RTB will write to them, assuming this passes through the Houses, will write to them. They will then have, from then until the 11th of January, they are protected as things stand until the 11th of January, based on the declaration they made under the RTVA Act, which was enacted back in July. It's after the 11th of January we want to ensure that they're protected. They don't need to do a declaration, but they do need to engage regarding an arrangement with their landlord and MABS protection. But they don't need to do that either if they've already done so. So if they've already engaged with the landlord and they have an agreement and it's working fine, there's a disapplication in here for those particular requirements. Now, sorry, I've dealt with that issue. Information at dispute, there is also in there, if the landlord can demonstrate that the tenant hasn't provided the required information. That was one of your last questions, I think. In reality, that kind of a situation would only be exposed at dispute stage, where somebody took a dispute and said, well, you know, you haven't provided the information that you were supposed to provide, therefore you're in breach of your part of the declaration.
But as soon as the landlord claims that and makes the counter application, the right to the prevention from being evicted is lifted, but might only be resolved at dispute stage.
It might only be resolved at dispute stage once the notice of termination is issued, because remember, a declaration from a landlord to a tenant and vice versa from a tenant back to a landlord, or sorry, the other way around, that in and of itself doesn't terminate a tenancy. That simply tries to avail of protections and then it disapplies that attempt because the landlord's in hardship or whatever. Separately, the landlord would then have to go through a process to terminate the tenancy. And as part of that process, the tenant could legitimately put their hand up and say, I want to raise a dispute because I made a declaration here, you countered that declaration, but I don't believe that you as the landlord meet the requirements for your half of the declaration, if you will.